Welcome to our case studies webinar for enhanced estate planning. Hello. Back in January, a young woman named Grace, with a bright future ahead of her, tragically lost her life. She was the college lab partner of my niece's husband. She had flown home to Wichita for her grandfather's funeral and was returning to school when disaster struck. She was an outstanding engineering student, and her flight was supposed to land in Washington, but on January 29th, 2025, that plane tragically collided with an Army Black Hawk helicopter. Just this week, I spoke with someone who were close friends with the parents of the Black Hawk pilot. Losing a loved one is devastating enough, but in the midst of grief, families are also left to navigate the overwhelming process of managing accounts, assets, and legal documents. If you don't have a plan in place, the state has one for you, and it may not be what you would have wanted. How much does it cost to protect your loved ones from that burden? A living trust typically runs between $1,500 and $2,500 or more. A pour-over will cost around $500. Financial and medical power of attorney documents are usually $150 each, but we cover those costs for you. Why do we do this? Because we both know you need it. We know it feels overwhelming, or that no one likes talking about death. Life gets busy, and it's easy to put off, but we've got your back. My goal is to make this process simple, stress-free, and thorough. From the moment you watch this video to the final step of transferring the deed of your home into the trust, my firm is here to guide you. I want you to be so impressed with our service that you share it with your family, friends, and coworkers, because they need this too. Let's get started. Case Study 1. Mrs. Darnold. This is the reason I have become so passionate about enhanced planning, as I am a major part in this story. Mrs. Darnold was the mom of a good friend of mine. One day she asked me to be the executor of her small estate. I reluctantly agreed, and we got to work. She didn't want to hire an estate attorney and thought we could write a will and 5 wishes on LegalZoom, which we did. Mrs. Darnold was very ill and knew her time was soon. In the meantime, I moved to California and got stuck there due to COVID. I told Mrs. Darnold it would be wise if she found somebody else, because if something happened, I would not be able to effectively manage her estate, as I couldn't easily get back. She agreed. When I was able to, I moved back to Colorado. She passed away shortly after. I went to her house the following day and found out I was still listed as executor. It was just a house with a mortgage, an annuity, her car, and furniture. We put the house up for sale. She indicated in her 5 wishes she wanted one son to get the bedroom set and her grandson to get the car. The annuity is a contract and always supersedes trusts and wills, so the only thing I had to worry about was the house with a mortgage. Mistakes made. There were many. First, a will still goes through probate. I didn't know this at the time. While we set her granddaughter as financial power of attorney, which was good, as she could access the bank account and pay the mortgage, we didn't know or expect probate to take as long as it did. Second, we didn't add a clause that anyone who contested will would get $0. What we should have done is set up a trust and change the deed of her house to be in the trust's name. Had she agreed to this, maybe there wouldn't have been $100,000 in lawyer fees, executor fees, storage fees, court fees, and maybe the kids would still communicate with each other. Lesson learned: if you have assets and you don't want an impartial court saying where things go, set up a trust and make sure you put your assets in the trust, as a trust without assets is just a piece of paper. Case Study 2. Mrs. Jones. Mr. Jones passed away. This couple had separate bank accounts. Mr. Jones passed seat without having a trust or a will, and especially in this case, a financial power of attorney. His bank account was frozen. Mrs. Jones couldn't access the account for months and had no way to pay immediate bills. Case Study 3. The Dietz family. In this case, the Dietz family are setting up a trust. One fantastic thing they're doing is gifting while they are still alive. Mr. and Mrs. Dietz are giving children and grandchildren both one-time payments and yearly payments in order to help out family and lower wealth. You can give yearly payments up to a certain amount. You can also give larger payments as you have a lifetime max you can give away. Please know the rules and fill out the right forms so the IRS doesn't come knocking on your door. Case Study 4. The Timber family. I call these people the Timber family, and you will see why. Grandpa Timber passed away. Him and his wife owned thousands of acres, which they leased to a logging company yearly. Then Grandma Timber passed away. She had nothing, not a will, trust, or power of attorney, nothing. So everything went to probate. The IRS doesn't care. They wanted their cut and sent a bill to the family for taxes due in 60 days. $950,000. The family doesn't have that kind of money, and still a year or more of probate left. The wonderful logging company felt bad, so they offered to buy the land for $950,000. The family got nothing. By the way, in Case Study 1, half of the kids' inheritance went to fees. I had to get a lawyer and eventually step aside. And not only do the kids not speak, but neither do I with my friend. What should have been a seamless transition took a year and a massive headache for everyone to finish. There are 3 reasons people don't get a trust, even though it makes life so much easier for their loved ones. 1, they don't like to discuss dying. 2, time. And 3, money. Pathfinder helps guide you through the process, including establishing the trust. First, you have to decide who and what. Secondly, get everything notarized and assets deposited into your trust. Third, changing your deed's name to the trust name. We will also guide you through this process on Rocket Lawyer. Pathfinder can issue the power of attorney and payable on death at no cost to you. Pathfinder can assist you in establishing your trust, normally $3,000 to $5,000 for only $100, shipping fee, and roughly 2 hours of work. You will no longer have anything holding you back. Case Study 5. The Case of Dale Earnhardt Sr. Ownership Structures and Control Conflicts. Dale Earnhardt Sr. was a successful NASCAR driver with considerable wealth and a business empire centered on racing. However, his untimely death in 2001 exposed weaknesses in his estate planning, particularly around the ownership of his business interests. One major source of conflict involved his son, Dale Earnhardt Jr., and Earnhardt Sr.'s third wife, Teresa Earnhardt. The dispute was centered on control of Earnhardt Sr.'s racing empire, including rights to his name, likeness, and related assets. Earnhardt Sr.'s estate, including his business holdings, was not clearly structured to indicate who would inherit what, which led to a power struggle between family members. Teresa Earnhardt had legal control over many of the business aspects, while Dale Earnhardt Jr. sought to establish his own legacy in racing. These tensions likely arose because there was no clear succession plan or structure that defined who would control the business interests after Earnhardt Sr.'s death. Probate and the need to avoid public conflict. Had Earnhardt Sr.'s ownership structures been more clearly defined through the use of trusts, joint ownership arrangements, or specific business succession plans, his family might have been able to avoid the public and protracted legal disputes that ensued. These disputes played out not just over the business itself, but also over personal aspects, like the use of his name and image. Lessons learned. The key takeaway from Dale Earnhardt Sr.'s estate case is that proper ownership and transfer strategies are crucial in preventing family disputes. Families with considerable wealth, especially those involving businesses, need clear estate planning, including trusts, wills, and business succession plans that leave no room for interpretation. Defined ownership structures to clarify who will control or benefit from specific assets. Transparency, particularly in blended families, so that all parties are aware of their roles and rights after the estate holder's passing. This case underscores how estate planning failures, particularly around ownership structures, can lead to painful and public disputes, overshadowing the legacy of someone as iconic as Dale Earnhardt Sr. Case Study 6. Adding directives in a trust is a powerful tool to ensure that your legacy and wealth are protected and properly managed for future generations. Lisa Marie Presley's mismanaged inheritance illustrates why it is crucial to incorporate clear instructions, reliable trustees, and robust oversight mechanisms within an estate plan. 1. Preserve long-term control over key assets. Why? In Lisa Marie's case, selling 85% of Elvis Presley Enterprises, EPE, generated short-term financial relief, but cost her long-term control and revenue from her father's legacy. Including directives that prohibit or limit the sale of key assets, ensures that these holdings continue to generate wealth and remain within the family. How? Specify in the trust that essential assets, such as business interests, real estate, or intellectual property, cannot be sold without the approval of multiple trustees or a set number of family members. You could also direct that income from these assets be reinvested or preserved for future generations. Conclusion. Lisa Marie Presley's cautionary tale shows how mismanaged inheritance and poor financial planning can quickly erode even vast fortunes. By incorporating clear directives into a trust, such as preserving key assets, promoting responsible financial management, controlling spending, appointing skilled trustees, and implementing oversight, you can ensure that your legacy is protected and continues to benefit future generations. Case Study 7. Prince Rogers Nelson, the legendary musician and artist, passed away unexpectedly on April 21st, 2016, at the age of 57. His death not only shocked the world, but also revealed that Prince had died intestate, meaning without a legally valid will. This lack of a clear estate plan resulted in years of legal disputes, a prolonged probate process, and significant financial and emotional burdens for his family. Legal costs and delays. The lengthy probate process, combined with legal disputes over the estate, racked up significant costs. Attorneys and estate administrators charged millions of dollars in fees over the years it took to settle the estate. By mid-2022, the legal fees had reportedly exceeded $10 million, further depleting the estate's value. The estate was officially settled in 2022, 6 years after Prince's death. The delays in resolving the estate meant that Prince's heirs had to wait years to receive their inheritance. Even after the settlement, ongoing management of his intellectual property and music catalog will continue to require legal oversight and negotiations. Lessons from Prince's estate. Importance of a will. Prince's estate highlights the importance of having a will or other estate planning documents in place. Without clear instructions, even an estate of modest value can become bogged down in legal disputes and probate, while larger estates face greater financial risks. Avoiding probate. Proper estate planning tools, such as trusts, can help avoid probate and ensure that assets are distributed according to the decedent's wishes. If Prince had set up a revocable trust, his assets could have been managed and distributed privately without the need for public probate proceedings. Case Study 8. Michael Jackson's untimely death in 2009 led to one of the most publicized probate battles in history, despite his considerable wealth and fame. Estate planning gaps. While Jackson had a trust in place, not all of his assets were properly transferred into the trust, which subjected portions of his estate to probate. The probate process was lengthy, expensive, and brought intense public scrutiny. Tax controversies. Jackson's estate was initially valued at $7 million by his executors, but the IRS disagreed and valued it at over $1 billion, leading to a significant legal battle. The estate ultimately settled with the IRS for $482 million in back taxes and penalties. Lesson learned: even with a trust, it's critical to ensure that all assets are correctly titled in the trust's name. Jackson's case highlights the importance of thorough and continuous review of estate plans to avoid costly tax disputes and probate delays. We put these celebrities in here, not because they are the only ones who need a trust, but because there is truth to all of their stories. The majority of us will never be a champion NASCAR driver, or related to Elvis or a worldwide superstar like Prince and Michael Jackson. By the way, did you know that almost every year Michael Jackson is the highest paid celebrity, dead and alive? And if you have assets and or beneficiaries, then you need a trust. If you are retired and worried about your legacy, you need a trust. If you are still currently working, but the thought of the state determining your legacy or guardianship of your children is problematic for you, then you definitely need a trust. If you are a young family and need to make sure if anything happens to you or your spouse that the kids go to someone you trust and may have financial help in place for when they will need it later in their lives, then you certainly need a trust. If you have a checking account, you need a POD, and if you are over 18 at the very least, you need a POA in place. Welcome to our short video introducing our new book, Important Information My Family Needs to Know When I'm Gone. What does my family need to know? This practical organizer is designed to keep all your vital information in one convenient place. It's crucial for your loved ones to know exactly where this organizer is located in the event of your incapacity or passing. Having this resource readily accessible ensures that your wishes can be honored, your assets protected, and any necessary steps taken without confusion or delay. By taking the time now to complete this organizer and store essential documents in a secure and known location, you'll be saving your loved ones from potential stress and countless hours of searching later. It's equally important to keep this information up to date. We recommend reviewing and revising the contents of this organizer at least once a year. Life is constantly evolving, so consider writing in pencil or having extra copies on hand if you prefer to use permanent ink. Since this organizer contains all the essential details your loved ones need, it should be the first item they access in times of need. Think of it as a roadmap to everything important. Make sure to inform your loved ones about its location so they know where to turn if something should ever happen to you. When the time comes, this book will be your family's best friend for many reasons. If you glance through the table of contents, you can see why. There are tons of sections for writing in important and pertinent information, as well as some fun and loving memoir pages found in the back of the book. One of the most important pages that you are going to have is the My Emergency Contacts page. Here you will most likely list your closest family members. On this page, you will see that there are plenty of rows to put in many family members or friends that you would like to be notified in the event of your passing. There is also an advisors and other entities to be contacted page for all of the professional people or places that you have policies, accounts with, etc. Get organized with the Documents Location Chart. This will help your family find where you keep all of your important documents stored. Now, don't worry, we didn't make this book completely all work and no play. Keep in mind that there are a good 40 plus pages of informative and needed information for you and your family when the time comes. Although, to bring some much needed insight and love into your family's life at that time, you can utilize the 15 plus pages for your memoir to them. There are all sorts of fun sections for you to fill out and add creative bits to. Add childhood stories, wedding and baby pictures, hospital bands from children's birth, etc. Always end your work with some fun. We would love to provide copies to your family, friends, coworkers, etc. How many copies would you like? Do you want to hand them out? Or if you are out of state, we can send them out to you. We want to meet with all of your friends, family, and coworkers so that we may give them the same no-cost, trust, and service that we provide to you or the person who gave you the book. We want you to have this as it will be essential for your family when you pass away. This helps you, your loved ones, and saves everyone's precious time and hard-earned money.
Let's review. Starting in the top left of the checklist, you will see 2 rows and 4 columns designated to you and your spouses. If applicable, basic information. This includes your names, dates of birth, phone number, and email address. Row 5 to 10 in columns B and C is where you and your spouse will be adding your beneficiaries for your trust. Section B will be for your beneficiaries, and Section C will be for your spouse's beneficiaries. Adding beneficiaries to a trust is crucial because it ensures that the assets held in the trust are distributed according to your wishes. Here are some key reasons why adding beneficiaries is important. 1. Defines who receives the assets. The primary purpose of a trust is to pass on wealth, property, or assets to specific individuals or organizations. Naming beneficiaries clarifies who will inherit these assets. 2. Avoids probate. Unlike a will, assets in a trust do not go through probate, allowing beneficiaries to receive their inheritance faster and with fewer legal hurdles. 3. Ensures financial security. A trust allows you to provide for loved ones, especially minors, elderly family members, or individuals with special needs, ensuring their long-term financial well-being. Moving on to row 12, you will see a section that asks for your homeowner's insurance agent name and company name. Keep in mind that we will contact your insurance agent for you to make sure that all T's are crossed and I's are dotted. Knowing your homeowner's insurance agent and company is important when setting up a trust because you're ensuring proper coverage. When you transfer your home into a trust, the title of the property changes to the name of the trust. Some insurance companies may require policy updates to reflect this change and ensure continuous coverage. Avoiding coverage lapses. If your insurance company is unaware of the trust, they might deny claims or even cancel your policy, leaving your home unprotected. Coordinating liability. Protection. Depending on how your trust is structured, you may need to update your liability coverage to reflect the new ownership arrangement properly. Mortgage and lender requirements. If you have a mortgage, your lender may have specific insurance requirements when transferring property into a trust. Your insurance agent can help navigate this process. Aligning beneficiary designations. If your trust is designed to pass assets to specific beneficiaries, ensuring that your insurance policy aligns with these intentions can prevent disputes and complications. By working closely with your insurance agent and company, you can avoid potential issues and ensure that your home remains fully protected under your trust. Moving on to row 15, you will see where it begins a checklist for your asset types, companies those assets are through, the account or item amounts, and beneficiaries for each kind of asset that you have. You will see rows 16 through 33 list the most common asset types, these being checking account, savings account, investment accounts, mutual funds, CD, annuities, vehicles, 401k, TSP, 403b, IRA, Roth IRA, precious metals, and some other sections for any other kinds of assets that you might have. Adding your assets and naming beneficiaries in your trust is crucial for several reasons. Avoids probate. Assets properly titled in the trust bypass the costly and time-consuming probate process, allowing for a smoother transfer to beneficiaries. Ensures control. You dictate how and when assets are distributed, providing structure for beneficiaries, e.g., minors, special needs individuals, or those with financial difficulties. Protects privacy. Unlike a will, a trust is private, keeping your financial affairs out of public records. Reduces estate taxes. Certain types of trusts can help minimize estate taxes, preserving more wealth for your heirs. Prevents legal disputes. A well-structured trust reduces the likelihood of family conflicts over inheritance. Provides for incapacity. If you become incapacitated, a successor trustee can manage your assets without court intervention. Covers all assets. Simply creating a trust isn't enough. Funding it, retitling assets into the trust, ensures your estate plan works as intended. By ensuring your trust is properly funded with assets and designated beneficiaries, you maximize its benefits and protect your legacy efficiently. Once you complete your assets section, you will move on to row 40, where there are some important things for you to think about regarding your trust. These will need to be thought about by both you and your spouse. Row 41 starts the first question with, who do you want for executor of your estate? Appointing an executor for your estate in relation to your trust is crucial for ensuring that your assets are properly managed and distributed according to your wishes. Here's why it's important. 1. Ensures smooth administration. The executor, also called a trustee if handling a trust, takes responsibility for managing your estate and ensuring that all assets are distributed as outlined in the trust. 2. Avoids delays and disputes. Without a designated executor, there may be legal battles or confusion about who should handle the trust, leading to unnecessary delays and conflicts among beneficiaries. 3. Manages financial and legal obligations. The executor ensures that all debts, taxes, and administrative expenses are paid before distributing assets, preventing legal or financial issues. The next row, row 42, asks who you want for your payable on death regarding your checking account. Adding a payable on death, POD, designation to your checking account is important when it comes to your trust because it helps ensure a smooth transfer of funds upon your passing. Here's why it matters. 1. Avoids probate. A POD account bypasses probate, meaning the funds go directly to the named beneficiary instead of being tied up in court proceedings. 2. Ensures immediate access. Your trust or named individual beneficiary can access the money immediately upon your death, which can be useful for paying estate expenses, taxes, or other obligations. 3. Maintains privacy. Unlike probate, which is a public process, a POD designation keeps your financial details private. 4. Aligns with your estate plan. If your trust is the beneficiary of the POD account, it ensures that the funds are distributed according to your trust instructions rather than defaulting to probate rules. 5. Flexibility and control. You can change or revoke the POD beneficiary at any time without needing to update your trust documents. On to the next row down, row 43, it asks for a POD regarding your savings account. The importance of this aligns with the previous information about a POD for your checking account. Row 44 asks who you and your spouse would like to be your primary power of attorney, financial. Adding a primary power of attorney, financial, to your trust is an essential step in ensuring that your financial affairs are properly managed in case of incapacity. Here's why it's important. 1. Ensures financial continuity. If you become incapacitated due to illness, injury, or aging, your designated financial power of attorney, POA, can step in to handle your financial matters, ensuring bills are paid, investments are managed, and assets are protected. 2. Avoids court-appointed guardianship. Without a power of attorney, your family may have to go through a lengthy and expensive court process to appoint a guardian or conservator to manage your finances. 3. Works alongside your trust. A trust typically controls only the assets you place into it. A financial POA can manage assets that may not be in the trust, such as retirement accounts, personal bank accounts, or newly acquired assets that haven't yet been transferred into the trust. 4. Prevents delays in decision-making. A POA allows an agent to act immediately, avoiding delays that could arise if court intervention is required. 5. Flexibility in financial transactions. The POA can handle important financial matters, such as signing contracts, filing taxes, managing real estate, and making investment decisions on your behalf. 6. Protects against fraud and exploitation. By appointing a trusted individual as your financial power of attorney, you reduce the risk of financial exploitation, as your agent has a legal obligation to act in your best interest. 7th, customized authority. You can specify the powers granted to your agent, including limitations, to ensure they only manage what's necessary. Key takeaway. While a trust is crucial for estate planning, a primary financial power of attorney ensures that your financial matters are handled efficiently during your lifetime, particularly if you become incapacitated. Together, they create a comprehensive financial protection plan. Next row down, row 45, asks for a secondary financial power of attorney for you and your spouse. Importance of a secondary successor financial power of attorney. A secondary or successor power of attorney financial acts as a backup if your primary power of attorney is unable or unwilling to serve. Here's why having a secondary POA is crucial. 1. Ensures continuity in financial management. If your primary agent becomes incapacitated, passes away, or declines to serve, the secondary POA can immediately step in to manage your financial affairs. This prevents disruptions in bill payments, asset management, and financial decision-making. 2. Avoids the need for court intervention. Without a secondary POA, if your primary agent cannot serve, your loved ones may have to go through a legal process to appoint a guardian or conservator. Having a designated successor simplifies transitions and avoids unnecessary legal battles. Row 46 asks for a primary power of attorney, medical, for you and your spouse. A primary power of attorney, medical, is crucial in the context of a trust because it ensures that someone can make healthcare decisions on behalf of the trust grantor, the person who created the trust, if they become incapacitated. Here's why it matters. 1. Ensures continuity of trust management. A trust primarily deals with financial and asset-related matters, but if the grantor becomes incapacitated, they may also need medical decisions made on their behalf. The trustee may not have authority over medical decisions unless explicitly granted in the trust document. 2. Prevents court intervention, guardianship, conservatorship. Without a medical power of attorney, Loved ones may need to go through a court process to obtain guardianship or conservatorship to make medical decisions. This process can be costly, time-consuming, and emotionally stressful. 3. Aligns medical care with estate planning goals. The medical power of attorney, POA, ensures that healthcare decisions align with the grantor's wishes, which can be crucial if the trust includes provisions for long-term care, Medicaid planning, or special needs planning. 4. Avoids conflicts between trustees and family. If the trustee is managing assets for the grantor's benefit but has no authority over medical decisions, disputes may arise between family members and financial managers. The medical POA clarifies roles and responsibilities, preventing potential legal and personal conflicts. 5. Facilitates payment of medical expenses. While the trustee can use trust assets to pay medical expenses, they may need to coordinate with the medical POA to ensure funds are available for necessary treatments or long-term care. How it works with a trust. The medical POA typically works alongside a financial power of attorney or successor trustee to ensure seamless decision-making. The grantor should ensure that both the medical POA and financial POA trustee are aware of each other's roles and responsibilities. Key takeaway. Having a primary medical power of attorney ensures that medical decisions are made according to the grantor's wishes, avoids legal complications, and allows for smooth coordination between healthcare and financial management, particularly when a trust is in place. Row 47 asks you and your spouse to designate a secondary power of attorney, medical. A secondary or successor. Medical power of attorney is just as important as the primary, especially in the context of a trust. Here's why having a backup is crucial. 1. Ensures decision-making continuity. If the primary medical power of attorney is unable or unwilling to serve, due to illness, death, unavailability, or personal reasons, the secondary POA steps in immediately. This prevents delays in crucial medical decisions, ensuring that healthcare and long-term care decisions remain aligned with the trust grantor's wishes. 2. Prevents court involvement. Without a secondary POA, if the primary is unavailable, family members may need to petition the court for a guardian or healthcare proxy. This process can be time-consuming and expensive and may lead to decisions that do not align with the grantor's estate and trust plans. 3. Avoids conflicts between the trustee and family. If medical decisions impact the financial management of a trust, e.g., long-term care, medical expenses, assisted living, having a clear chain of authority for medical decisions ensures coordination with the trustee or financial power of attorney. This minimizes potential conflicts among family members or between the medical and financial decision-makers. 4. Provides flexibility in long-term planning. If the grantor has a trust that includes provisions for medical care, disability, or Medicaid planning, a secondary medical POA ensures that there is always someone available to advocate for their medical preferences. This is especially important in elder care or special needs planning within a trust. 5. Protects against unforeseen circumstances. Life is unpredictable. Someone designated as the primary POA may decline the responsibility, become incapacitated, or even move far away. A secondary medical POA ensures that there is always a trusted individual ready to step in. How it works with a trust. The trust grantor appoints a primary and secondary medical power of attorney in their healthcare directive or advance directive. The trustee or successor trustee should be aware of these designations to ensure medical and financial decisions align, particularly if the trust is funding healthcare needs. Key takeaway. A secondary medical power of attorney acts as an essential backup, ensuring uninterrupted decision-making, preventing legal disputes, and maintaining coordination with the trust's financial management. Every well-structured estate plan should include both a primary and a secondary medical POA for comprehensive protection. Next up is Row 48, which asks you and your spouse if you would like your children to receive assets in equal amounts. You might want all of your assets distributed equally to your children through a trust in situations where fairness and equality. You want to ensure that each child receives the same amount to avoid potential conflicts or feelings of favoritism. No unique financial needs. None of your children have special financial circumstances that would require unequal distributions, such as disabilities, debts, or differing levels of financial stability. Avoiding family disputes. If you believe equal distribution will minimize potential disagreements or legal battles between siblings. Preserving family harmony. You want to promote unity and prevent resentment among your children. All children have similar relationships with you. There are no significant differences in your relationships that might justify an unequal distribution. No special contributions by any child. None of your children provided extraordinary care, financial assistance, or contributions to your estate that would warrant an unequal share. Estate size is large enough. If your estate is substantial, an equal split may ensure each child receives a meaningful inheritance without financial strain. Your children have similar financial stability. No child requires a greater share due to financial hardship or life circumstances. Simplicity in estate planning. Equal division is straightforward and can simplify the administration of the trust. Avoiding favoritism and potential legal challenges. Unequal distributions can sometimes lead to legal disputes, so an equal split can reduce the likelihood of contests. Now in Row 49, you have the option to either have your assets from the trust go to your children up front or spread out after a certain age. Whether you distribute trust assets to your children immediately or spread them out over time depends on various factors, including financial responsibility, maturity, and long-term goals. Here are some common situations for both approaches. 1. Distributing assets upfront, lump sum or full access at a certain age. You may choose to give your children their full inheritance immediately if they are financially responsible. Your children have demonstrated good money management skills and won't squander the inheritance. They are adults with stable careers. If they are already well established, a lump sum could be beneficial for investments or major life purchases. The estate is small or moderate. If the inheritance isn't large enough to require long-term management, an outright distribution may be simpler. You trust their judgment. If your children are mature enough to handle wealth responsibly, there's less need for restrictions. They have an immediate need. They may need funds for education, home purchases, business ventures, or paying off debts. You want to avoid ongoing trust administration costs. Trusts require management fees, and outright distribution eliminates these expenses. Second, spreading out the inheritance, staggered or conditional distributions. You might want to delay or structure the distribution over time. If your children are young, minors or young adults might not have the life experience to handle a large sum responsibly. You want to encourage financial responsibility. Releasing funds in stages, e.g. at ages 25, 30, 35, can prevent reckless spending. You want to protect against poor financial decisions. If a child has a history of bad spending, addiction, or financial instability, spreading payments reduces risk. To provide long-term security, a structured distribution ensures your children have financial support throughout their lives. Concerns about divorce or lawsuits. If your child gets divorced or is sued, assets held in a trust are often more protected. Business or investment goals. Gradual payments can be tied to financial goals, such as funding education, starting a business, or home ownership. Special needs or disabilities. A special needs trust can ensure long-term financial support without jeopardizing government benefits. The second to last row. Row 50 says that distributions can be different depending on your child's needs, and to list all children and what ages you will want them to receive assets. The final row. Row 51 asks you and your spouse to think about if you have any pets, who you would want to be the beneficiary of them if something were to happen to you. Please note that when we begin to build your trust, you will want all of this information figured out and filled out.
Let me ask you a few important questions about your current retirement accounts, whether it's a TSP, 401k, IRA, or any other type of plan. Do any of them offer you up to 34% return over a 2-year period, with you receiving the first 34% before anything else? Probably not. And yet, we all know the market occasionally performs that well. Do they guarantee that you'll never lose money, even when the market drops? Definitely not. Do they dollar cost average your contributions? Yes, anytime you add to your retirement account, you are automatically dollar cost averaging. That's a standard feature. But here's the real question. Do any of those accounts lock in your gains every single month after that first 2-year period? So you can never lose those gains, no matter what the market does? Absolutely not. If you want to learn about the only investment on the planet that gives you the first 34%, protects you from loss, and locks in your monthly gains, then get in touch with the agent who invited you or the person who invited your friend who brought you here. This is something you don't want to miss. Here is an insightful scenario between a financial planner and his retired client.
Hi, John. How's retirement treating you?
Not bad, just trying to make sure my money lasts. The markets make me nervous these days.
Totally get it. And you're not alone. A lot of retirees are looking for a way to grow their money without risking it. That's what I want to show you today.
I'm all ears, but is it safe?
Very. This investment is designed so that you can't lose a dime, no matter what the market does. Your principal is protected. If the market crashes, your account won't drop at all.
So no losses, even if the market tanks?
Exactly. And even better, you still get a chance to grow your money. It's tied to the S&P 500, and you earn up to 34% of the market's growth every 2 years.
That sounds too good to be true. What's that?
It's a fair trade-off. You don't get all the upside, but you get the first 34% over each 2-year period. So if the market goes up 10%, you get 10%. If it goes up 40%, you get 34%. And again, if the market drops, you don't lose anything.
That seems pretty strong, especially if it's safe.
Over the last 20 years, the S&P 500 has averaged about 12% per year. With this strategy, even with the 34% cap, you could realistically average around 10% a year based on historical numbers, with zero downside risk.
Okay, I like the sound of that. Can I add money over time?
Actually, you can't add to it later. But here's how it works. We take your initial investment and spread it out over the first 12 months, investing a portion each month. This way, you're not dumping it all in at once. You're not trying to time the market.
Oh, so it gets averaged in automatically?
Exactly. It's like easing into the pool instead of jumping all at once. That strategy, called phasing in or dollar cost averaging, helps smooth out market ups and downs during that first year.
Makes sense. And you said the gains lock in?
Yes, starting after the second year, any growth you earn gets locked in every single month. Once you gain it, it's yours, permanently. Even if the market drops later, you don't give any of it back.
That's the kind of peace of mind I'm looking for.
Then this might be a perfect fit. It's all about protection first, growth second, and no surprises. Want to go over the numbers together?
Possible scenarios: subject and spouse die with or without a will. Estate goes to probate. They live in Fairbanks where it's 40 below zero and you have to pay $1,000 a month to heat home and plug-in car. Will the court-appointed executor take care of all this before pipes break, engine block freezes, and probate is finally finished? Lesson learned: no matter what the scenario, your wishes are best abided by if it is a trust. In most states, a will takes 12 months to go through probate. Same scenario, but any location. There is a mortgage on property. The executor may have to sell assets to pay mortgage for a year. Not at all what client intended. 3. Pour over will. One thing you do not want to include in your trust is your vehicle. Instead, you put it in a pour over will. This is for everything not included in the trust. The reason for this is you do not want the trust vulnerable to a lawsuit if there is a tragic accident you cause. A pour-over will is a type of will used in conjunction with a living trust. It ensures that any assets not transferred to the trust during the testator's lifetime pour over into the trust upon death, keeping the assets aligned with the trust's terms. A pour-over will complements the living trust by ensuring any assets unintentionally left out of the trust. During life, they are still managed according to the trust's terms. Let's recap. Advantage of trust over will. A trust can be used to avoid probate, can provide creditor protection for the inheritance you leave to beneficiaries, can protect governmental benefits for a person with disabilities, can reduce estate taxes, and can administer assets for minor beneficiaries without court intervention. A will cannot do any of these. Remember, changing a house deed name to your trust's name is on average about $50 at your county's office. Advantage of will over nothing, control over. Asset distribution. A will allows you to specify who receives your assets and in what amounts. Appointing a guardian. If you have minor children, a will lets you designate a guardian to care for them. Minimizing family disputes. A clear will can help prevent conflicts among family members. Simplifies the probate process. Although having a will doesn't avoid probate, it often makes the process smoother and faster. Tax benefits and estate planning. A well-structured will, especially with advice from an estate planner, can help minimize estate taxes or other financial burdens. Disadvantage of nothing. You leave all decisions up to impartial court.
Pathfinder Retirement welcomes you to our informative video, breakdowns of your Vanilla's estate planning documents. Here are the key points from the Jordan Revocable Trust document. 1. Trust creation and purpose. The document establishes a revocable trust for estate planning purposes. It is designed to manage and distribute assets efficiently, avoiding probate and providing for beneficiaries. Second trustee and successor trustee. Names the initial trustee, likely the grantor, Jordan's spouse. Identifies successor trustees who will manage the trust if the original trustee becomes incapacitated or passes away. Defines the powers and responsibilities of the trustee, including investment decisions, asset management, and distributions. 3. Trust assets and management. Lists the assets that are included in the trust, e.g., real estate, bank accounts, investments. Provides guidelines on how the trustee should manage these assets, including any restrictions or requirements for asset preservation. 4th, beneficiaries and distributions. Names the individuals or entities that will receive assets from the trust. Specifies conditions for distributions, such as age-based milestones, education expenses, or discretionary distributions based on need. May include provisions for the surviving spouse, children, or other heirs. 5th, revocability and amendments. Confirms that the trust is revocable, meaning the grantor can change or dissolve it during their lifetime. Provides a process for amending or revoking the trust, usually requiring written notice or formal documentation. 6th, incapacity or death of grantor. Describes what happens to the trust if the grantor becomes incapacitated, e.g., due to illness or cognitive decline. provides instructions for successor trustees to take over management, outlines how assets should be distributed upon the grantor's death, often avoiding probate. 7. Taxes and expenses. Addresses tax implications of the trust, including income and estate taxes. Assigns responsibility for paying trust-related expenses, such as legal fees, trustee compensation, and maintenance costs for trust assets. 8. Governing law. Specifies which state's laws will govern the trust's interpretation and administration. This can impact tax treatment, legal disputes, and trustee responsibilities. 9. Special provisions. Includes any unique conditions or restrictions, such as spendthrift clauses to protect beneficiaries from creditors, stipulations on how funds can be used, e.g., education, healthcare, charitable donations, provisions for special needs, beneficiaries to ensure they do not lose government benefits. Here's a breakdown of the certification of trust, trust establishment and existence. The trust is officially executed and currently in existence. It is a revocable trust, meaning the settlor, creator, retains the right to modify or terminate it. Roles and authority. The settlor and trustee are the same person. The trustee has full authority to manage the trust. If multiple trustees are involved, 2 trustees must act unanimously. More than 2 trustees must act by majority vote. Trustees can delegate powers under certain conditions. Beneficiaries. During the settlor's lifetime, they are the primary beneficiary of the trust. Legal and tax considerations. The trust uses the settlor's Social Security number as its taxpayer identification number. The official title for property ownership follows the format trust name, dated execution date, trustee name, trustee. The trust remains valid and unmodified in a way that contradicts this certification. Third-party reliance. External parties, e.g., banks, financial institutions, can rely on this certification as proof of the trust's existence. They are not required to verify the full trust document or question the trustee's authority. Notarization requirement. The document must be signed and notarized to be legally valid. A notary public confirms the identity of the trustee and applies an official seal. This certification serves as a summary document to verify the trust's existence and the trustee's authority without disclosing the full trust details. Here's a detailed summary of the Jordan pour-over will, testator, and intent. The will is created by Jordan, intending for their assets to be transferred into a trust upon passing. Executor and administration. A specific person, likely named in the will, is designated as the executor or personal representative, responsible for handling the estate, paying debts, and distributing assets according to the will's instructions. Pour-over provision. Instead of distributing assets directly to individuals, this will transfers all remaining estate assets into a pre-existing trust. The trust then determines how the assets are managed and distributed. Beneficiaries, likely the spouse and potentially others, is named as a primary beneficiary. The details of distribution may be outlined in the trust rather than the will itself. Guardianship for minors, if applicable. If Jordan has minor children, the will might specify who should serve as their legal guardian. Debts and expenses. The document may outline how outstanding debts, taxes, and administrative expenses should be handled before assets are transferred to the trust. Final arrangements. The will might contain preferences for burial, cremation, or funeral arrangements. Revocation of previous wills. Typically, this type of will revokes any previous wills or codicils made by the testator. Here's a breakdown of the Financial Power of Attorney, POA document. 1. Purpose and scope. Grants authority to an agent to manage financial matters on behalf of the principal. The powers granted can be broad, allowing control over various financial and legal matters. 2. Powers granted. Principal must select. The principal can authorize the agent to handle real estate transactions, buying, selling, leasing, or managing properties. Personal property transactions, managing goods, valuables, and possessions. Banking transactions, accessing accounts, making deposits, withdrawals, handling loans. Business operations, managing a business or financial interests. Insurance matters, handling claims, modifying policies. Estate transactions, managing estate-related affairs. Retirement plans, managing retirement benefits. Claims and litigation, handling lawsuits, settlements. Government benefits, managing Social Security, military benefits, etc. Records and reports, accessing financial records, tax filings. Voter registration and absentee ballots, managing election-related matters. Other matters, any additional specified powers. Third, special authority optional and requires explicit selection. Trusts, creating, modifying, or revoking trusts. Gifting authority, making gifts within legal limits. Beneficiary designation, changing financial or insurance beneficiaries. Transfer on death deeds, modifying property transfer upon death. Survivorship rights, altering shared asset rights. Delegation of power, allowing the agent to assign their authority. Retirement benefits, waivers, waiving certain annuity rights. Fiduciary powers, exercising powers on behalf of the principal. Electronic communications, accessing digital messages under federal law. Fourth, agent execution requirements. The principal can choose whether multiple agents, if appointed, must act jointly or individually. 5. Effective date options. The POA can take effect immediately upon signing or only upon the principal's incapacity. If effective upon signing, the principal can decide whether incapacity revokes it. 6. Revocation and termination. The POA remains valid until the principal revokes it by executing a new POA. The specified time period, if any, expires. The principal becomes incapacitated, if stated in the document. 7. Legal protections and liabilities. Third parties, e.g., banks, financial institutions, relying on the POA in good faith, are protected from liability. Refusal to accept a valid POA may result in civil penalties, damages, and legal fees. 8. Notarization requirements. The document must be signed and notarized to be legally binding. If someone signs on behalf of the principal, that person cannot be an agent and must also have their signature notarized. Key points from the Jordan Letter of Wishes. Purpose: a non-binding document providing guidance to the trustee on handling trust assets in alignment with the settlers, Tony Jordan's, values and intentions. Primary intentions: ensure beneficiaries' financial security while promoting self-sufficiency. Avoid excessive distributions that may dilute wealth for future generations. Encourage responsible financial behavior and personal growth. Values and principles: support basic needs such as education, healthcare, and living expenses. Promote financial responsibility and discourage extravagance. Encourage entrepreneurial and educational pursuits. Allow for charitable giving if beneficiaries' needs are met. Trust distributions, directed towards family, multiple generations, or named beneficiaries. Covers essential living expenses, education, and healthcare. Extraordinary events. Trustee is granted discretion in cases of unforeseen hardships like natural disasters, health crises, or divorce. Minor children. Trustee should support a guardian in caring for minor children until they reach maturity. Distribution guidelines. Annual or staged distributions, with potential increases at certain ages. Trusted advisors. Trustee encouraged to seek guidance from legal, financial, and tax professionals. Final notes. The letter is subordinate to the trust agreement in case of inconsistencies. Only the most recent letter should be considered valid. Here are the key points from the Healthcare Power of Attorney, POA. Agent appointment. Primary agent. a designated individual to make healthcare decisions. Alternate agent, a backup agent if the primary is unavailable. Agent's authority, authorized to make all healthcare decisions, including consenting to or withdrawing treatment, hospitalization, and surgery. Can choose and transfer medical providers as needed. Effective date, authority takes effect immediately and continues indefinitely unless revoked. Life-prolonging treatment, options to accept or refuse life-sustaining treatment in cases of terminal or permanently unconscious conditions. Not selected in this copy. Pain management requires initials to authorize pain relief medication and treatment. HIPAA authorization. The agent has full access to medical records and health information. Revocation and amendments. Supersedes all prior healthcare directives. Can be revoked or modified anytime while competent. Effect of divorce. If the agent is a spouse, their authority is automatically revoked upon divorce. Liability. The individual or their estate is responsible for medical expenses, not the agent personally. Copies are valid. A copy holds the same legal effect as the original. Witness and notary requirements. Requires 2 witnesses, who are not agents, relatives, or heirs. Must be notarized for legal validity. Here's a summary of the Jordan Family Estate Report. 1. Overview. The report provides a full financial and legal review of the Jordan family estate, analyzing assets, liabilities, and future management strategies. It aims to ensure financial stability, legal compliance, and long-term growth while preserving family wealth across generations. Second, financial summary. Total estate value, a breakdown of the estate's net worth considering both tangible and intangible assets. Revenue streams. Income sources include rental properties, investment dividends, and business profits. Expenses and liabilities. Covers mortgage payments, maintenance costs, taxes, insurance, and legal fees. Investment performance. Evaluates the return on investment, ROI, of stocks, bonds, and business ventures. Debt analysis. Identifies any loans or outstanding liabilities affecting liquidity. Third, property and asset portfolio. Real estate holdings. Detailed valuation of residential, commercial, and undeveloped land properties. Investment portfolio. Breakdown of stocks, bonds, private equity, and business ownership stakes. Liquid assets. Overview of cash reserves, bank accounts, and other easily accessible funds. Business interests. Ownership stakes in family-run businesses or external partnerships. 4. Legal and estate planning. Wills and trusts. Ensures proper inheritance distribution among heirs. Legal compliance. Aligns with tax laws, estate regulations, and financial reporting requirements. Ongoing legal matters. Any disputes, litigations, or unresolved property claims are noted. Succession plan. Strategies for transferring control of businesses and assets to the next generation. 5. Future planning and recommendations. Wealth preservation. Recommendations for diversification, reinvestment, and risk management. Tax optimization. Strategies to reduce tax burdens on inheritance and capital gains. Growth strategies. Identifies opportunities in real estate expansion, new investments, or restructuring businesses. Family governance. Ensures smooth estate management and decision-making for future generations.
Rocket Lawyer step-by-step instructions. Sign up. Quitclaim deed process. Cancellation of service. Disclaimer. As mentioned previously in the Case Studies webinar video, it's crucial to avoid probate on your home to ensure a smoother transition of assets. The way to do this is by transferring ownership of your home into your trust. You own the trust, and the trust owns the house. This process will not impact your existing mortgage or homeowner's insurance. Please follow these instructions to complete your quitclaim deed. If you have any questions along the way, don't hesitate to reach out to us. We're here to help. Slide 1. Search and select Rocket Lawyer. Instructions. In your browser, type in Rocket Lawyer into the search bar at the top. Click on the first link titled Rocket Lawyer. This is a sponsored ad that takes you directly to the Rocket Lawyer site. Slide 2. Start free trial. Instructions. On the Rocket Lawyer homepage, locate the button in the top right corner labeled Start Free Trial. Click on this button to begin the account setup process and access free features. Slide 3. Sign up for an account. Instructions. Fill in the email field with your email address. Create a password that is at least 6 characters and includes at least one number. Click the Continue button to proceed. This confirms your agreement to Rocket Lawyer's terms of service and privacy policy. Slide 4. Dashboard. Start new document. Instructions. After logging in, you will land on the dashboard. On the top right corner, click the Start New button to begin creating your first document. Slide 5. Select Make Documents. Instructions. On the What would you like to do next page, click on the Make Documents box. This will allow you to start creating a legal document from Rocket Lawyer's template library. Slide 6. Search for document. Instructions. On the Make Documents page, click on the Search Our Documents bar. Type the name of the document you need, for example, Quitclaim Deed. Slide 7. Select Quitclaim Deed. Instructions. After typing Quit into the search bar, a list will appear. Click on Quitclaim Deed from the drop-down list that appears below. Slide 8. Begin the Quitclaim Deed. Instructions. You will be taken to the Quitclaim Deed overview page. Click the orange Make Document button to begin creating the deed. Slide 9. Indicate property location. Instructions. Under Where is the property located? Select the state where the property is located using the drop-down menu. Click the Continue button once the state is selected. If you need clarification, click the Need help with this question? Link for assistance. Slide 10. Select a state. Instructions. From the drop-down list, choose the appropriate state where the property is located. Once selected, click the orange Continue button to proceed with document creation. Slide 11. Enter preparer's name. Instructions. In the Name field, enter the full name of the person preparing the document. Click the Continue button to proceed. Slide 12. Identify grantor type. Instructions. Choose the option that best describes the type of grantor, the party giving up interest in the property, an individual person, a married couple, a divorced couple, a business, a trust. Select the one that applies. Only one at a time if there are multiple. Click Continue to move forward. Slide 13. Enter grantor's name. Instructions. Enter the full legal name of the grantor exactly as it appears on the current deed. If the grantor is part of a couple, only list one spouse's name here. Click Continue to proceed. Slide 14. Marital status of grantor. Instructions. Select either yes or no to answer whether the grantor is married. Marital status may affect legal wording in the document. Click Continue after selecting. Slide 15. Enter grantor's address. Instructions. Enter the following details for the grantor's physical address. P.O. boxes are not accepted. Street address, city or municipality, county/parish. State, select from drop-down, zip code. After completing all fields, click Continue to proceed. Slide 16. Where will the quitclaim deed be signed? Instructions. Use the drop-down to select the state where the quitclaim deed will be signed and notarized. Enter the county or parish where this will take place. Click Continue to move to the next section. Slide 17. Confirm grantors. Instructions. Review the listed grantor name that you previously entered. If needed, you can click Add Another to include a second grantor. Once correct, Click Continue to proceed. Slide 18. Identify type of grantee. Instructions. Under Type of Grantee, choose who is receiving ownership. In this case, select Trust, as highlighted by the arrow. Click Continue to proceed. Slide 19. Enter grantee name. Instructions. Enter the name of the person, business, or trust that should appear as the grantee on the new deed. Make sure to type it exactly as it should appear on the document. Click Continue to save and proceed. Slide 20. Enter trustee's name. Instructions. Enter the name of trustee, the person who will be signing on behalf of the trust. After filling in the name, click Continue to proceed to the next step. Slide 21. Enter the grantee's address. Instructions. Fill in the grantee's physical address fields. Do not enter a P.O. box. Address. City or municipality. County/parish. State, select from drop-down. Zip code. Once complete, click Continue. Slide 22. Confirm grantees. Instructions. Review the listed grantee information. Only first spouse for couples. If applicable, e.g. for individual revocable trusts that are not joint, click Add another to add a second grantee, like a spouse's trust. Once confirmed, click Continue. Slide 23. Property address. Instructions. Enter the property's address where the title change is taking place. Address. City or municipality. County/parish. Zip code. If the property is in an unincorporated area, check the box at the bottom. Click Continue. Slide 24. Property's parcel number. Instructions. Enter the tax or assessor's parcel number, APN, found on the current deed. Steps to find deed info if you do not have a current deed document or real property assessment notice for APN, etc. Step 1. www.levelsets.com. Step 2. Select the county that your deed has been recorded through. Step 3. Find your county and select the recorder website and info under that county's info. If you do not see your county, you may have to manually search your county's recording or clerk's office on the web. Make sure that you access a government website for free and correct information for lookups. This website will typically end in .gov. Step 4. Once you have arrived at the next page, please scroll down until you see your county's information again on the left side of the page. Click on the link that says County Recorder Website. Step 5. You will now be directed to your county's record site and may search and look up your deed information. This is often needed to correctly identify the property. Click Continue. Slide 25. Money exchange between parties. Instructions. Choose whether money will be exchanged as part of this transfer. Select No if this is a gift, family transfer, or for estate planning. This will insert language such as $1, 1.00, and other good and valuable consideration into the deed. Select Yes only if actual payment will be involved. Click Continue to finalize this section. Slide 26. Legal description. The system asks whether you want to type out the legal description of the property now, or attach a copy of it later. The legal description must match what's on the current property deed exactly. So many users choose to attach it later to avoid errors. Make your selection. Click on the circle next to. I'll type out the legal description here, if you have the exact information on hand and would like to manually input it. Or click on the circle next to. I'll attach a copy of the legal description later if you would like to attach the document after you print it. This is the recommended option if you're unsure of the exact wording or want to use a scanned copy. After making your selection, click the orange Continue button to proceed to the next section. Slide 27. Transfer. Effective date. Enter the date. The quitclaim deed will become effective. This is typically the date the grantor signs the document. Click Continue to proceed. Slide 28. Mineral Rights Reservation. Select No if the grantor is not keeping any rights to minerals, oil, or gas under the property. Click Continue to move on. Slide 29. Life Estate Reservation. Select No to indicate the grantor is not retaining the right to live in or occupy the property after the transfer. Click Continue to confirm. Slide 30. Tax Statement Recipient. Taxpayer name. Enter the name of the person who will receive future tax statements, typically the grantee. Address. Enter the full mailing address, city, state, zip code. Complete all remaining fields. Checkbox. Check the box if the deed should also be mailed to this address. Click Continue. Slide 31. Choose your trial and start using your document. Select the Rocket Legal Trial Plan. $0 for 7 days, then $39.99 per month billed monthly. Includes unlimited documents, Rocket Sign, and legal Q&A. Slide 32. Enter your payment information. 1. Review that you will not be charged today. Enter your first and last name. 3. Input your card number, expiration date, month/year, and security code, CVC. Enter your billing zip code. Click Yes, Start My Free Trial. Slide 33, Processing Confirmation. Wait while your payment and account setup are being processed. Slide 34, Document Draft Complete. Click Download to save your completed quitclaim deed. Slide 35, Choose File Type for download. Choose the PDF format to download your quitclaim deed in a print-ready version. Slide 36. Confirm your download. 1. Click the Downloads icon in your browser. 2. Click on quitclaimdeed.pdf to open your downloaded document. Slide 37. Review and print the quitclaim deed. 1. Scroll through the thumbnail pane to view all pages. 2. Click the printer icon to print a hard copy of your document. Slide 38. Navigate to Member Settings. 1. Click your name profile icon in the top right. 2. Select Member Settings from the drop-down. Slide 39. Cancel or downgrade membership. Click the Downgrade My Membership and Lose My Benefits link. Slide 40. Membership Overview. 1. Note your trial expiration date. 2. Click Manage Membership to make changes. Slide 41. Offered Downgrade option. Click Continue to downgrade if you do not wish to switch to the $4.99 per month Essentials plan. Slide 42. Final confirmation before downgrade. Click Complete Downgrade to confirm cancellation and switch to the free version. Slide 43. Downgrade confirmation. Click Back to Member Settings after seeing the confirmation message. Slide 44. Reload Member Settings. Click the Reload button in your browser to refresh and confirm new membership status. Slide 45. Free membership activated. Account now shows free membership status. You can print, sign, and download existing documents. Next steps. 1. The blank Exhibit A page is where you can attach the legal description of your property or land if it wasn't manually entered into Rocket Lawyer. Once that's done, gather all the documents from your estate plan and have them notarized with a witness present. Most local banks offer notary services and may charge a small fee. 2. Then take the quitclaim deed document, along with your certification of trust, to your county recorder's office to transfer the deed of your home into the name of your trust. This process typically costs around $50. 3. Once everything is finalized, be sure to store all of your documents in a safe and secure place. It's important that your trustee and power of attorney know where to find them in the event of your unexpected passing. 4. If anything changes, please don't hesitate to let us know so we can keep your documents up to date. Also, if you have not done so already, don't forget to cancel your Rocket Lawyer account. Wishing you a great day and peace of mind, knowing your legacy is now protected. Thank you.